5, 4, 3, 2, 1. On that analogy, an administrative decision is revocable while a judicial decision is not revocable except in special circumstances. Full stop. Exercise of power of a subordinate legislation will be prospective and cannot be retrospective unless the statute authorizes such an exercise expressly or by necessary implication. Full stop. The principle laid down in section 21 is of general application. Full stop. The power to rescind mentioned in section 21 is without limitations or conditions. Full stop. It is not a power so limited as to be exercised only once. Full stop. The power can be exercised from time to time having regard to the exigency of time. Full stop. When by a central act, power is given to the state government to give some relief by way of concession and / or rebate to newly established industrial units by a notification, the same can be curtailed and / or withdrawn by issuing another notification under the same provision, and such exercise of power cannot be faulted on the ground of promissory estoppel. Full stop. Para. The purpose of the General Clauses Act is to place in one single statute different provisions as regards interpretations of words and legal principles which would otherwise have to be specified separately in many different acts and regulations. Full stop. The purpose of the General Clauses Act is to place in one single statute different provisions as regards interpretations of words and legal principles which would otherwise have to be specified separately in many different acts and regulations. Full stop. Whatever the General Clauses Act says, whether as regards the meaning of words or as regards legal principles, has to be read into every statute to which it applies. Full stop. Further, power to curtail and / or withdraw the notification issued under section 49 of the Electricity (Supply) Act, 1948, giving rebate is implied under section 49 itself on proper interpretation of section 21 of the General Clauses Act. Full stop. Therefore, power to curtail and / or withdraw the notification issued under section 49 of the Electricity (Supply) Act, 1948, granting certain benefits was available to the respondents. Full stop. By virtue of sections 14 and 21 of the General Clauses Act, when a power is conferred on an authority to do a particular act, such power can be exercised from time to time and carry with it power to withdraw, modify, amend or cancel the notifications earlier issued, to be exercised in the like manner and subject to like conditions, if any, attached with the exercise of the power. Full stop. It would be too narrow a view to accept the chargeability once fixed cannot be altered. Full stop. Since the charging provisions in the Electricity (Supply) Act, 1948 is subject to the state government's power to issue notification under section 49 of the Act granting rebate, the state government, in view of section 21 of the General Clauses Act, can always withdraw, rescind, add or modify an exemption notification. Full stop. No industry can claim as of right that the government should exercise its power under section 49 and offer rebate, and it is for the government to decide whether the conditions are such that rebate should be granted or not.